Thank you for watching the training on scope of duty. It is important that you understand the scope of duty of your appointment as a suitable representative. This document has information about the limits on your scope of duty. It also talks about how to request another appointment or ask for an expansion of your duties. Your scope of duty is limited to the docket numbers in the appointment letter. In most cases, your duties will include communicating with your client to prepare for an OAH hearing, participating in the hearing, reviewing the order, and assisting your client to fill out a petition for review for the next level. If you were appointed after the process has started, it may be because your client did not ask for an accommodation in the beginning. Many of the steps you will take to complete your duties are outlined in your training document on the role and responsibilities of a suitable representative. Here is a simple way to think about it. In your appointment letter, there is a docket number, or several docket numbers. Is the issue in that docket number? If it is, then it is in your scope of duty. If it is not, then it is outside of your scope of duty. We will get into some additional details in a little bit. Your client signed and accepted your appointment. However, your client may not understand the limits of your scope of duty. Your client may ask or even expect for your help on other matters before and after your appointment ends. You may need to remind your client about your scope of duties. Here are some examples of things they may ask you to do that are outside of your scope of duties. Help with this case at the next level of appeal, help on another open case, fill out a new request for hearing, help or advise with other civil or criminal matters. Appointments under the suitable representative rule are limited to hearings before OAH, not any other state agency. For example, if your client wants you to represent them before the Board of Industrial Insurance Appeals, BIIA, that will always be outside of your scope of duties. You cannot expand the scope of duties under WAC 1024-010 to include hearings before other adjudicative agencies like BIIA or before municipal, district, superior, or other courts. If your client asks you to represent them again before OAH and you're willing to, they must ask for a representational accommodation and they may request to have you appointed. Your client must ask for an accommodation in every case before OAH. Any representative could potentially be sued. As a volunteer, you are entitled to have the state defend you as long as you are within your scope of duties. If you want to read more, a copy of the laws regarding defense by the Attorney General are included at the end of the PDF document of this presentation. We will discuss more about liability in other sections of the training. If you are ever unsure about your scope of duty, please ask the ADA coordinator. Sometimes it is not clear whether a new action by the referring agency requires another appeal. You might even be told that your client does not need to file a new appeal. You will always want to work with the ADA coordinator to learn if OAH will approve a request for another appointment or an expansion of your scope of duties. The process may seem unnecessarily complex and feel like there is too much red tape or jumping through the hoops. We have structured the process to try to protect you. We want to keep the time you spend helping your client focused on the topic in your appointment letter. OAH only has authority to ask you to help them with a specific appeal. OAH does not have authority to ask you to represent or help them with all the important issues they have in their lives. You can expect that multiple issues will creep into the picture. Recognizing the limits of your scope of duty might become complex. If your client appeals new issues and makes an accommodation request each time, the process will be clear and you will not have to guess. Here are some scenarios to consider. Your scope of duty is for a case about a food assistance appeal. However, your client also applied for medical assistance. Even though these are on the same application form, different state workers would process each request. Your client will receive separate notices regarding each program. Your client's food assistance appeal may be in process several weeks before he receives the notice of decision about his medical assistance eligibility. Your client must ask for an appointment again when appealing the medical assistance decision. You are only currently appointed to help with the food assistance appeal. If your client would also like your help with the medical assistance appeal, you must first contact the ADA coordinator. you will need another appointment letter. An agency may send multiple notices about the same or similar issues. An agency sets a date for an applicant to submit information to prove eligibility. The applicant does not respond in time and the agency denied benefits for a lack of information. The applicant appealed and requested an accommodation. You are appointed to be the applicant's suitable representative. Once you become involved, you help the client provide more information. As a result, the agency issues a second letter notifying your client of its decision. If the agency continues to deny benefits, the second letter does not create a new docket number. Your scope of duty is still the appeal of the denial of benefits. If the agency issues an approval letter, you need to ask your client if they accept. If your client accepts, you can help them withdraw the appeal and OAH will dismiss the case. It could be that your client is happy to be approved, but they do not like the amount awarded. If your client disagrees with the amount of benefits awarded, your client has the right to appeal. Your client must ask for an accommodation again when they appeal the benefits awarded. So that's the amount of benefits awarded. You are currently only appointed to help with the denial of benefits. If your client would also like you to help with the appeal about the amount of benefits, you must first contact the ADA coordinator and you will need another appointment letter. In another scenario, your client appealed termination of benefits. You are appointed to help with that appeal. Sometime later, the agency sends your client a notice of overpayment. As a note, the client may receive the notice of overpayment after your appointment has already ended. Either way, this is a new appeal. Your client will need to file a request for hearing to dispute the overpayment notice. Your client must ask for another accommodation. The new appeal will be outside your scope of duties, even if you are still working on the termination of benefits case. Your client may have many medical issues. Each of those issues may be a separate appeal. The first will be a decision about whether your client is financially eligible. The client's medical needs are decided only after financial eligibility is established. If your appointment is to help a client appealing a denial based on the financial ineligibility, your scope of duty will not cover future appeals related to medical needs. Consider the breadth of medical needs a client with a disability may have. Each issue likely involves a separate appeal. For example, your client may be seeking help with dental or dentures, vision, durable medical equipment, prescription drugs, surgical and other procedures requiring advance approval, mental health or behavioral health issues, in-home personal care. Okay. Lots of different issues there, and each would likely be a different appeal. Your client might have multiple cases at OAH. Remember, you are only appointed to the case in your appointment letter. Here are some examples of other appeals your clients may have. Each appeal may involve different agency representatives, different agencies, different schedules, and may be assigned to different OAH offices. An unemployed claimant may have denials involving job separations from more than one employer. An unemployed claimant may also have an appeal for commissioner-approved training. A parent may have children from more than one relationship and have child support issues with each of the other parents. A Medicaid client may have disputes involving prescription medication, a wheelchair replacement, and a request for dental work. A DSHS, Department of Social and Health Services, a DSHS food assistance recipient may also have a claim for unpaid wages with the Department of Labor and Industries. Remember, you are only appointed to the docket number in your letter, and you may want to alert the ADA coordinator that your client has other cases. You may be able to represent your client on all of their cases. If so, you would receive additional appointment letters. If you are ever not sure about your scope of duties, please contact the ADA coordinator. Now, your appointment ends when the review deadline passes. In this example, you see that there is 30 days to file a petition for review with Superior Court. Your duties end after you help your client file a petition at the next level of review. Your client may want you to continue to act as their representative in the next level of review. OAH only has authority to accommodate clients in our hearings. Your client will need to ask for accommodations at the next level. For example, the party will need to ask for ADA accommodations from the DSHS Board of Appeals or the Employment Security Commissioner's Review Office or the Superior Court. It is outside of your scope of duty to represent clients before the higher authority. Thank you for taking this training. We encourage and appreciate feedback to improve any of the training videos and materials. Please send suggestions to the OAH ADA coordinator at OAH_ADA coordinator at OAH.wa.gov. Thank you for participating in this training. We'll see you in the next video.